A few folks from Orange and Osceola counties in the state of Florida got together with a Miami attorney and filed a lawsuit against the state of Florida and Governor Ron DeSantis for the passage of Senate Bill 4C, which we discussed here on Valiant Renegade a few weeks ago. That bill, of course, removed the special privileges of one Reedy Creek District, the independent district that was formed back in 1967 that has helped the Walt Disney Company quite a bit since its inception. Now, Disney can still go back and reapply under the new Florida rules. We've discussed that in the previous video with Legal Mindset. But I was back on last night with Legal Mindset on his own channel to talk about this lawsuit. So we've got some clips put together for you to watch. So let's get into it. Here we go. Renegade Online. Well, welcome back, folks. Another great day here at Valiant Renegade. It's good to see everybody out there. Before we get to these clips with Legal Mindset and discuss this new lawsuit in the state of Florida and what he and I think about this, please make sure you hit that like and subscribe button, hit that notification bell, share this sucker out on social medias, and of course, as always, do leave a comment before you head out the door today. We need those comments. That really helps the YouTube algorithm, and it's great to see what you folks out there think of all of this stuff going on with Disney right now. So here's the clips, reprinted and reproduced with permission of Legal Mindset. Whether this is, Disney shills or whether it's just an attorney that's maybe trying to get a little notoriety, or it's Disney handed this attorney, hey, look, we'll pay you a retainer fee.
Yeah.
Go out and find some plaintiffs.
Yes.
And just make some noise. Maybe knowing that this goes nowhere, but at least just making some noise to kind of, be able to say that, all this is bunk. And Disney, obviously, look, Disney themselves, and this is key, they really have not responded to this publicly themselves.
See, that's so interesting to me that they haven't acknowledged this, probably because here's the thing. Here's where they're kind of damned if you do, damned if you don't. If you acknowledge it, then you're kind of putting your stamp of approval on it. And at that point, this thing, because, as I'm going to break down here, because it's so crappy, because it's so low quality, it's going to get dismissed, and it's going to look like, oh, Disney's lost in court, even though it's not Disney, but because you put your stamp of approval on this, it becomes something that you're kind of invested in. Versus if they lose this, if this is dismissed, as it will be, as I think it will be, rather, then Disney can say, hey, it's not our lawsuit. We still can bring a lawsuit, or rather Reedy Creek can bring a lawsuit.
Right.
And Reedy Creek really is the entity with standing to bring an injunction if they wanted to try for that. That'd be fully on Reedy Creek to bring.
Yeah, that's why I don't think Disney is going to say much about this, because it does not involve Disney. And I know as we go through some of the complaints in this suit, especially that are particularly ridiculous. Because again, it doesn't involve Disney. This bill did not. Senate Bill 4C did not involve the Walt Disney Corporation. It involved Reedy Creek, which is supposed to be a separate, autonomous entity from Disney. Even though everybody knows Disney owns all of the property inside the boundaries of Reedy Creek. Even though everybody knows that Disney is basically appointing the people who are governing Reedy Creek. It's still a separate legal entity.
Exactly. That's the point here. So to jump right into this, because this goes right into the facts here, which is, and we're going to hit the relevant facts here, guys. So the petitioners, by and through their counsel, filed a complaint against the state of Florida and request that a bill signed into law Thursday, April 21st, 2022, be declared unconstitutional. So that's the first part, and in direct violation of a written commitment Florida entered into in 1967 when it agreed to form the Reedy Creek Improvement District. Florida passed the bill with the intended purpose of eliminating, think about this very carefully, eliminating a special legal status that allows Walt Disney World, Disney, to operate as an independent government, Reedy Creek, around its Orlando area theme parks. In just making this statement that the sole purpose is to give a special status to Disney, they're acknowledging the ridiculousness of this. Like just saying that and saying that out loud, saying, oh, we're giving Disney a special status that nobody else has in the state of Florida, that exists nowhere else.
And if they had just said, what struck me is the Florida passed the bill with the clear intended purpose of eliminating the special legal status of Reedy Creek, but they said that allows Walt Disney World to operate as an independent government.
See, this is the problem. That alone could end up screwing over Reedy Creek.
That blurs the lines beyond, I think, what Disney would have preferred.
Yes, they preferred this to be a sham government, not a complete like for example, a sham government no one sees rather than exposing it to light of day.
Yeah, when you drive into Walt Disney World Resort, don't y'all notice the signs that says "Welcome to beautiful Reedy Creek"? No, they don't exist.
No. The bill violates Florida taxpayers' federal constitutional rights. Well, we'll get into whatever the hell that is, as well as their clearly delineated rights under the Florida Bill of Rights for taxpayers. Well, let me get into this real quick. One of the key components in the Florida Bill of Rights for taxpayers, and in general in the Florida Constitution, specifically Article 7, is that no tax is levied except pursuant to law. And for these people to assert, which they will, that any tax would be applied to them as people who do not live within Disney World would be a tax that goes against Florida law. So in fact, Florida law is protecting those people in Orange County and Osceola County from being taxed. So this is already a misstatement here. So it goes on to say the stated and undisputed reason, well, once again, undisputed by who? By delusional people in the newspapers behind the bill is to punish Disney World and subsequently Florida taxpayers. Okay, so this statement is a lie, right? The reason why they're passing it is to punish Florida taxpayers? No. Governor DeSantis has been clear on his intended punishment of Disney, although he claims the elimination of Disney's special district will not affect Central Florida taxpayers. And he cites Newsweek, right? Florida is dismissing and attempting to eliminate Disney World's First Amendment rights, as the bill is intended to hurt Disney because certain company employees expressed disagreement with Florida's recently passed bill known as the Don't Say Gay bill. I don't know. Valiant, have you gone into this at all? Because I always go to this.
I've read this. Yes, I've read this.
That's not even the Don't Say Gay is not in the bill.
Yeah, it's not. It's not.
In the bill.
Again, that was one of these things that jumped out at me. Like, this is in a lawsuit, a formal lawsuit, to where, Florida's recently passed bill known as the Parental Rights in Education bill is what the bill is called. House Bill 1557. Don't say gay is a euphemism that was invented by flipping Twitter.
Yes.
And that is not, again, this is one of these, the so-called blah, or what it's called. We can say that on YouTube, and we can say that on, and again, I'm not a lawyer, but I've been around the law for 20 years working in the financial planning industry. And I know enough to where it's like, there's one thing for us to say things on YouTube, say things on Twitter. It's another thing to put it in a damn lawsuit. It's another thing to use it as legal language when you're, I found this whole thing as I'm reading it more and more, just scratching my head going, what?
You're losing your credibility, right? It's a complete loss of credibility. It's saying, okay, if as a lawyer, you're supposed to state objective facts. When you're stating stuff that literally is not just unhinged, it's detached with reality. It's like the judge can't even find the bill. If he types it in, he'll be able to find it via Twitter, but he's not going to find it on the Florida Senate website that way. He's not going to find it anywhere else. He's got to actually have the number, the name, everything else. You're literally barring the judge from going in and finding it. If you could have just said the parental rights in education, which colloquially has also been referred to as blah, 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 right? Like, that's fine. You can even put it in parentheses if you want to. Like, that's your little slang name you're going to use in your complaint. That's okay. We do that all the time. It's kind of passive aggressive. That's totally fine. But they just decided to totally neglect that. AD says, is this really going to raise taxes in the two counties by $2,000? No. No, absolutely not. That's ridiculous. That's a crazy projection that they're bringing out.
I think it's like we talked about before. If as Legal Mindset said previously on this, if Florida state law says that you can't service bond debt that was previously issued outside of the geographic area that it was previously issued upon, that means that regardless of whether Reedy Creek still exists or not, even if Orange and Osceola counties would have to service the debt, quote unquote, the only physical areas they could tax to actually financially service that debt would be inside of the Reedy Creek boundaries, or at least what once were.
Exactly.
And that's Buena Vista, Lake Buena Vista, which is still going to be there as a city, technically, I guess, and Bay Lake.
Yes.
Which is 100% owned by Disney. So at the end of the day, Disney still has to pay it.
So let me show you guys something which is really interesting. So this is why we want to subject them to Florida law. Now, this is a little bit like, guys, the language is a little bit murky here. But right here this is from Florida statute. This is for independent special districts. This is when you kind of merge a district. But there's procedure here in Florida law that says, like, when you merge a special district, an independent district, which essentially Reedy Creek is an independent district. So if you were to merge it, you only exercise the authority to levy and collect revenues. So, i.e. bond money, right? Because it's collected as a revenue on the tax roll within the boundaries of the subunit, which was previously granted to the component unit. So essentially what they're saying is only within Reedy Creek, only within the thing that's being merged, right? Could you actually exercise that authority to collect the bond money, to collect those funds. Now, the problem is that, once again, Disney was created by special act and authority. And because it created in this weird method, which never should have happened in the first place, never should have been granted in the first place, they can say, oh, well, we weren't created under that process. That doesn't directly apply to us. Well, it should. And under the language of the bill, which dissolved Reedy Creek, it can. It actually can. Because they're allowed to reform as a new district, but under current Florida law. So they'd be subject to provisions like that in terms of dealing with the bond money. So
I like to use the term, like you said, everybody plays by the same rules.
Yes.
Everybody, and this is all this is. Disney is not at this point, at least, well, it's not Disney, but Reedy Creek, which is, part of Disney, kind of, sort of. But they don't want to use that in a legal argument, clearly. But the point is that we want Reedy Creek, or the Florida legislature, Ron DeSantis wants Reedy Creek to play by the same rules as everyone else. And they're not right now. And they haven't been since 1967. Obviously, the Reedy Creek thing, based on our discussion last time, was written effectively outside of the bounds of 189 and 190.
Yes.
And people have been citing 189 and 190 left and right as why DeSantis can't do this, or the governor's, or whatever. And it's like, well, because 189, it's like, well, for anything that was formed under 189 and 190, this is what you have to do. It's like, but Reedy Creek wasn't formed under that. That's the point.
Yes.
That's why I was curious. Okay.
We're trying to get them subject to that like they should be.
And the other 4 districts that this bill cancels effectively.
Yes.
Not just Reedy Creek. There's 4 others that were formed outside of 189 and 190.
The Villages is a community that's mostly retirees. Fun fact, it had the highest syphilis rate in the United States for a while, but that's neither here nor there. That's just a fun fact. That's just a fun fact. So apparently they would put different like loofahs on their go-karts to tell like whether they were swingers or what they were into. It was a weird thing. It's a weird situation in the Villages. That being aside, the IRS was looking at some of the bonds they issued for the roads, and they were looking at the Villages and saying, hey, wait a minute. And now the Villages was like 10 or 12 different special districts formed under 189 or Chapter 190 of the Florida statutes. And so they looked at one of them, and the only property owner within that specific district was the Villages Corporation, was literally the Villages Development Company. And only they would ever be the owner within that area. It was like the little downtown area, and they were going to retain ownership of that. So the IRS looked at it and said, hey, you guys are a single taxpayer. Therefore, the bonds you issued, the tax-free bonds you issued, those really shouldn't be tax-free. They should be treated like corporate debt. They should be taxable bonds. So they said, guess what? Not only should those bonds be taxable, and you guys got to pay tax on that, this is the IRS saying it, But we're going to declare that according to the IRS, you villages, this specific district in the villages, once again, there's many, this specific district, you are no longer a political subdivision. You are no longer a government. The IRS effectively dissolved the villages unit. So guess what the villages did? They responded and they said, hey, it's not fair. Guess who else did it? Well, let's look right here. This is the villages argument to get that thrown out. This is in 2014. They said it is inequitable to single out the center district, that's the villages, by the way, for the application of the new standard. The IRS has administratively ignored any public or electorate standard in recent examinations of other districts. For example, dun, 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 Reedy Creek Improvement District, a district with similar single majority landowner election structure. So they're literally saying, you're looking at us, you're hating on us, but you're ignoring Disney. Well, I wonder why the IRS is ignoring Disney, right? And let me just be clear. The IRS said in its conclusion, F you, we don't believe what you're saying. We're not giving you relief, right? We're not declaring you a political subdivision. So everything stands. So let's jump back into the actual lawsuit itself, because this just gets even more hilarious. Like I keep laughing here. So number 4, it says the lawsuit is one of the very few mechanisms available to taxpayers in such matters. Taxpayer lawsuits such as this one are meant to check and restrict official government misconduct. This is just so weird. Like it's first of all, this is the wrong mechanism for this. Second of all, you have like no standing. And third of all, I don't think it's meant to check official and restrict official government misconduct in general. You're talking about specific misconduct. For example, if somebody assessed your property with a tax that shouldn't be there, then yeah, you do need to check that. But in general, no, taxpayers aren't intended to just sue governments over things that don't affect them directly. Plaintiffs in this matter are alleging and will prove that that the bill, which was signed on Friday, will lead to significant injury to taxpayers, and they have a personal stake in the outcome of this litigation. This is interesting. So, okay, they're going back again, saying they signed it for their to punish Disney, right? Number 6 says that. Here we go. Here's the part that's funny. A number of experts have publicly opined in this matter, and the great majority indicated that the new bill will probably, so no certainty there. So they're saying they have probably lead to increased taxes for the residents of Orlando and that live throughout Florida. Why is there no citation here?
Thank you. Like they didn't list one damn expert, not an article, not a name, not nothing. It's just like some people up on Twitter said that this would suck. That's it. That's the fucking lawsuit. Some people on Twitter said this could suck. I was blown away by that. I just absolutely blown away.
They didn't even include a tweet. Like at least put the tweet in there, you know? Like, let me know what tweet are you relying on?
There's nothing there. Nothing there.
Zero. And this is the thing, guys. This is the modern derangement. Is that they think people are experts. What? Because they say they're experts. Mm-hmm. They go, well, I'm an expert on this. It's like, yeah, you have as much credibility as I do, or you do, or hell, chat. You guys know more than they do. You know, because you're actually paying attention to facts on this case versus your feelings and your positions or whatever you're paid to say, right?
I kept looking for footnotes. I'll just say that I didn't.
There's none.
I know.
And here we go. Here's another one. A statement with no citations. The bill is threatening to take thousands of jobs away from Florida. How? What jobs?
Who's the 45 people in double wides? Working
they're
at Reedy
still going to be there.
I know. That's what I'm saying.
They're still employed by Disney. I mean,
they're living rent free in those double wides. Disney put them there. Disney owns the double wides.
And this whole claim, and that, you know, I've seen people make this in good faith, literally not in good faith. I think it's a bad faith argument, but I've seen people make this argument with a straight face, rather, that Disney will move out of Florida. I literally, the level of idiocy to even imply that is possible is beyond the pale. Mm-hmm. I don't know where in the United States, other than maybe Alaska, where you could find this much open land to develop on. I mean, I just really don't know where you could find it, like where you would go and find like the equivalent of San Francisco in terms of mileage that's completely unencumbered and completely unpurchased. You're going to be able to buy it out and create your own infrastructure in there and build everything up.
40 square miles of open wilderness in an area that is very accessible to travel, and most importantly, that could be in a climate that would allow the park to remain open 24/7, 365.
Boom.
That's why they're there. That's why they were looking around here in New Orleans at the same time when they were looking in Florida. They were looking all along the Gulf Coast. They wanted that. Walt wanted that because he knew, yeah, it'd get hot in the summer, but we don't have to shut down for 1, 2, 3 months in the wintertime because of snowfall. Dollywood shuts down like 3, 4 months out of the year. They have to.
They have to. And that's not even that north, because I used to live in Waynesville, North Carolina, like really nearby.
It's Gatlinburg.
Nearby Gatlinburg. And it's Gatlinburg. It's not Michigan, you know? So even if Dollywood was to shut down, imagine if they tried to move this to Ohio. You just wouldn't be able to do it. So literally the claim here is in the complaint, say plaintiffs who are property owners in the surrounding counties. So, okay, that's what their claim. They took so long to get to it. Like that's their claim standing, is that they're property owners. They fear, not that they know, they haven't been submitted a tax bill. They fear that they will now have to assume the tax burden. The fear. So they're suing over fear. First of all, you don't sue over a fear that is not even been realized. It's not been tangentialized, that you have no documentation for. The county hasn't levied any tax at this point. Once again, the fear is well-founded. Where's your citation? Like it's almost like the lady doth protest too much, you know? It's well-founded. Sure. So yeah, it will actually impose. So they're putting down here, Disney for decades has essentially been able to function as its own municipal government. Yes, and they shouldn't have been. The designation gave Disney certain rights, and as such, they were able to avoid certain building regulations. That sounds horrible. I mean, Valiant, how does that sound to you? Like when you're putting in a complaint, oh, well, it's so great that we allowed them to avoid building regulations, fire codes, and, other municipal codes. I mean, does that sound good to you? Is that like a good look?
I wouldn't think. It's like, why would you be bragging? I mean, this is exactly what we were talking about before. This is what we were saying, and they're now putting it in black and white in this lawsuit, citing it as a reason why this is a bad thing. And it's just, it goes to the point that Disney is not playing by the same rules as everyone else. They have their own special set of rules. That's the point. It's like literally the lawsuit is making the argument for the state of Florida.
Yes.
It's unbelievable.
And you see this. So this is one of the few quotes they had, which is Scott Randolph, who's the tax collector for Orange County. He apparently told the Post, just the quote, which may be taken out of context here. I haven't read the original article, but says, so they are going to have to raise property taxes. This is a huge increase in the citizens of Orange County that they will have to pay every year. First of all, you got to understand the tax collectors are political people, right? Scott Randolph has been subject to many Disney donation over the years. So is it a surprise that a uncreative political shill might make a statement which may be wrong, right? Because as I pointed out, there's many vehicles to avoid having to increase taxes. And in my opinion, it would be unconstitutional and unenforceable to try to make the bonds a general obligation of Orange or Osceola County. It's a huge problem. So the parties, they're all people who live in Kissimmee and one in Orange County. I guess so they were trying to get an Orange County plaintiff and an Osceola County plaintiff. So these guys live in Kissimmee and these guys live in Orange County. Obviously, you've got jurisdiction, you've got venue. That means like the court has jurisdiction over it. And they're claiming this is a First and 14th Amendment violation.
This is where it really goes off the rails for me.
Here we go. Yeah, this is the insanity here. So the state of Florida violated its statutory, contractual, and third-party obligations. I'm like, what? Okay. Statutory and contractual obligations signed in the improvement district, which forbids it from dissolving the district. First of all, this guy's capitalization, like that should be lowercase, but whatever. Until the district's over $1 billion in bond obligations are fully met and discharged, and all of that's discharged. I've covered this one, but I'll say it again. Yeah. I think that this right here deals with modification or impairing the district. So essentially saying that while the district is undissolved, while the district is operating, they're not going to say, the state won't say, hey, we're going to prevent you from issuing these bonds, or we're going to stop you from issuing bonds, or stop you from collecting on bonds while the district is in operation. As I said before, Florida is Disney's daddy here, the Reedy Creek's daddy. They created the district. They have the power to destroy it. To try to say that you can never have you can never dissolve this district as long as there are bonds outstanding, it's insane. Special districts, governments, any government always has bonds outstanding. So we've got that bond argument kind of tackled. So Reedy Creek made a statement to bondholders saying that Florida will not in any way impair the rights and remedies of bondholders. They were citing the original. So in the statement to bondholders, they just cite the original act, which okay. But also, if you go to the bonds themselves, by the way, guys, this is the Reedy Creek bonds. I just pulled up the latest issuance. But if you look over here, it says specifically the board of directors has the power to levy and assess the ad valorem tax on all taxable and real and tangible property in the district, right? In the district. They don't assert in the bonds anywhere that they have the power to make that a general obligation in Orange County, that they have the power to impose that on people in Osceola County or outside of the district. The only thing they ever assert in the bonds themselves is that they only have power over property in the district. They don't ever assert the fact that they've got power to make things general obligation or expand beyond the district, beyond the boundaries of the district. So just know that that's very important when they're talking about trying to expand things to Orange and Osceola County. All right. Next cause of action here. Florida violated its third-party statutory and contractual obligations to plaintiffs. So standing to enforce such an agreement lies primarily with the signatories, but also should include effective parties. If not, those most likely to suffer, the taxpayers, will not be able to defend their interests. So their argument is that because hypothetically, maybe in an insane scenario, the taxpayers might be subject here, they have to be able to defend their interest by bringing a claim. That does not fly. It's almost like saying, hey, because Ford is being sued and I'm thinking about buying a Ford, then I've got standing to come in here and sue. It doesn't make much sense. It doesn't make much sense, especially when it's a hypothetical.
That's exactly right. That's what I read as well. And I didn't understand that either. I'm like, how can you sue on the grounds? Well, we think something could happen. What? It's like you're suing for damages that have not occurred and might not ever occur. And it just this whole thing seems incredibly preemptory to the standpoint of being like ridiculous the way they word this. It's just
and trying to say, so this is the part where
we don't even know if Reedy Creek will actually really get dissolved. That hadn't even happened yet. We still have a year before that happens. And as you said in our last video, 2 weeks. They could file for recertification and probably get it in a matter of a few weeks. And they probably would get it. And the difference is they'd be playing under modern Florida law as opposed to their own special little set of, my ball over here. No. You're going to play on the court with everybody else. They can still get it. And then the whole bond issue would be moot. They're going to continue to serve. The district could still be there playing under new rules. And that's what this is all about. To me, I would think.
Yeah, I completely agree.
So I don't understand anything about this lawsuit at all.
I really
I'm not a lawyer, but I just I read this and I'm like, nothing's happened yet. What the piss are you suing on?
And to say that, or they use a quote here, the Reedy Creek statute says is that the powers of the district, whatever the district, impacts its inhabitants and landowners and will benefit all properties, persons, and enterprise within the district. I'm like, okay, but you guys aren't within the district. So they're saying that they're beneficiaries of that? At what point you guys aren't even in the district? Yes, you're not in it.
Yeah.
You have no standing. So you literally, your own argument just doesn't give you the ability to do that. And they try to jump under here. Under Florida law, the doctrine of third-party beneficiaries provides that a person may sue to enforce a contract. There's no contract. Under Florida law, this does not meet the definitions of a contract. This is why this lawyer, I'm like, I don't know if he knows what he's talking about here, because There's no contract here. This isn't an implied contract. They're under Florida law. So I don't know what they're trying to generate where there's a contract. They're trying to use contractual theory, trying to bootstrap that into this. This is the same thing that Jacob Schumer tried to do in his article in Bloomberg. He tried to bootstrap contractual law into the statute, and that's not how Florida law works. Sorry, that's just not how that works, particularly regarding bonds, bondholders, and bond obligations. You can't just bootstrap contracts from one area and slap them into another area and say, hey, this is going to work. No, it doesn't work that way. That's it. That's all. That's the whole lawsuit. That was the end right there. After that, they just asked for the relief, asked for an injunction, asked for them to stop this, get rid of the bill. That's it. That's all. Super short, light on citations, light on any evidence, light on any facts. And I just don't think they have a claim here. I don't think they have a claim. If it got past 12B6, it would definitely get handled before by summary judgment. This is something that's not going to go to trial. Like, there's no way in hell. But I'd put my money, I'd put a 95% chance on a 12B6 dismissal of this case, just because it's so light. The facts are there. It's speculative. It's something that is based on things that haven't happened yet. I think where you might be able to get a case, I'm not saying it'd be successful, but if Orange County or Osceola County tried to put something on the tax roll, then that would be different. But they are not going to do that. And we talked about that in our previous video, which you can check out, in which I'm sure I'll be talking about a lot more. Politically, they cannot do that, right? Because they will be voted out of office. And number two, there's limits in Florida to the amount you can increase taxes every year. You cannot increase taxes more than a certain percentage every year. They can't just all of a sudden double people's taxes. It cannot happen under Florida law.
Thanks for watching. Please make sure you hit that like and subscribe button, hit that notification bell, share it out on social medias, and leave a comment before you head out the door. Please make sure you also go check out Legal Mindset's channel and check him out on Twitter and me on Twitter as well. And until next time, take care, folks.